The first thing I want to let you know is the rulemaking process this department went through took 2 years. We started in the fall of 2023 by releasing an email that for 60 days asked and inquired of licensees and the public, do you have any recommendations, any corrections, any questions at all about the rules as they are standing at that time versus new rules that the department is planning to update? What did the public and the licensees want changed? What suggestions did they have? And the department received a lot of comments through that, and that was very valuable because when we actually moved into the beginning of true rulemaking, and that was the docket opening, we had all of these comments already prepared that we could tell the public and licensees were interested in knowing more about or concerned about changes. And so the department went through those rules, made preliminary suggested changes based on those comments, and then released that in the initial docket opening for more comments from licensees and the public. Now, statute requires that the department, during rulemaking, allow 30 days for public comment. But because it had been 20 years since rules had been updated or changed, the department made the decision, why don't we open that up for 60 days? So in that initial comment period on the suggested draft rules, the public and licensees had 60 days. Obviously, there are organizations that sometimes need a little more time to talk to all of their members. So some of the associations and organizations that were within the real estate sector had a little time as well, because we gave them a heads up, hey, we're going to be doing this. So why don't you talk to your members and make your suggestions? And we even had in-person meetings with a few of them as well. So through the rulemaking process, that docket opening was where we got a large number of very precise, very detailed comments that we could then go and take as we, as a department, went through every single rule that was there in that rule book. We pulled out a large number of rules that needed something changed. It could have been a few words, it could have been an entire rewrite, or anything in between. And we as a department sat down with those public comments and started to discuss and started to amend those rules. Now, that took a few months because, as you can imagine, that is a lot of documentation, statutes, and common practice changes that happened over that 20-year period. So it took us a while to go through not only the comments, but our own thoughts and what we as a department experienced when licensees came to us with questions or subdividers came to us with plans and were trying to submit or get answers to questions. So we took several months to talk about that. And then we released another draft formal rulemaking proposed plan. And once again, instead of allowing just the 30 days, we went ahead and extended that to 60 days of public comment and licensee comments. Once again, we got an enormous number of really detailed comments. Educators gave us great comments, subdividers gave us great comments, builders gave us great comments. And during that time, we didn't just wait for people to come to us. We actually went out into the various communities. We solicited comments from cities, towns, and counties. We solicited comments from professional organizations involved in economic development throughout this state. We solicited comments from other state organizations that are involved in some way in economic development. And we asked them to please read the proposed rules and then provide their comments. We asked chambers of commerce to do the same thing because they have business people who are members, not just real estate agents, but lots of different real business people. So all those organizations, all those other government entities, and then the public in general and our licensees, our educators, our subdividers, all provided us great feedback and information, which is why we were able to get such detailed changes that our stakeholders, which was in this case, almost everyone who had anything to do with real estate, we had them and we were able to make sure that we were accommodating requests that were necessary and needed, wording it so that people had better clarity. And we would send back sample language for people who had made those suggestions to read and actually say, yeah, that makes more sense to me now. So we went through a lot of work, and that's why it took so long. Our final formal rulemaking was finally released earlier this past fall, late summer, early fall. And through that process, that is when our rulemaking went into the formal GERC process, the Governor's Regulatory Review Council, who has to review all of our proposed rules and then decide if they would pass all of them, none of them, or some of them. And to do that, GERC within their system, after we submit, they go through, they have attorneys who look it over, make sure that everything's legally okay. And then they open it up for 30 days of public comment to them. Some comments came to us and we would forward those comments to GERC so that they had them. And then we had a workshop that was open to the public that GERC hosted. And then a week later, GERC hosted the final decision-making meeting. And at that decision-making meeting, we were approved. At that point, it went to the Secretary of State's office for publication, and she had it published as the GERC changes stood. So everyone can understand what was being changed, added, deleted. And that stood there for 60 days as people could read it. And then it became final. Now, that rules package was only part of the total rules administrative code that real estate has. So right now, as of December 13th, those changed rules became embedded into the larger real estate administrative code, what we call rules. So you can go to the Arizona Department of Real Estate website, and on there you will find the law book. In that law book, the changes have been embedded into the entire book of administrative code for real estate. You will notice there is pink highlights. Pink highlights are the items that were changed within that rule. So I hope that's helpful to you as you go through and you read and start to make changes to your business or not, depending upon what you're doing and what affects you, and become more aware of what the rules are now currently as we are administering them here at the Department of Real Estate. So now I'm going to introduce Commissioner Nicolson and Deputy Commissioner Neat as they go through and highlight the rules we have had the most questions on.
Well, I'm excited to talk about rules because I think the industry has been waiting a long time for them to catch up to 2026. I mean, I can't believe it's 2026, but I've been a licensee for 20 years, Commissioner, and I am thrilled with the changes.
Yeah, it was time. Every 5 years, the department is supposed to do a rule review over half of the rules. And the department had been doing 5-year rule reviews, but there hadn't ever been any changes to the rules. And so we went through, we did it comprehensive, as Liz just explained to everyone. And we want to go over some of the highlights for you, but in no way, shape, or form does this cover all of the rule changes that happen. You really need to go to the law book online to be able to see those. So
yeah, and please go to that email you received this morning and you'll see the link directly to the law book and save that in your favorites tab.
Yeah. Okay, here we go. So the first thing we changed over were definitions. We needed to better define some things. Credit hours. It used to say the majority of a continuing education class had to be about the subject that was supposed to be taught. And we actually did have some educators that kind of skirted the line. And so you got 49% infomercial about the services that they offer and 51% agency law. And that was really not okay with me. That was really frustrating. That's not what continuing education to keep your license current, to learn, to be the sharpest tool in the box is supposed to be about. So we redefined that. We wanted to still allow for some flexibility where the classroom maybe takes you off into the weeds and you end up talking about legal issues instead of agency law or something without that being a violation. But now the law reads that 80% needs to be applicable to the course category that you're getting CE for. So that was the first one that we changed.
That one was great because I don't know how many of you have sat through intros that you were like, wait, it's been an hour and a half. So we're really glad to get everybody on track. And modules were a really big deal too. So now we have 50-minute modules. Commissioner, will you speak about that?
Yeah, so in distance learning, it references modules, but our book didn't actually have a definition for what those modules were. So a module is anywhere from 12 and a half to 50 minutes. When you're doing that online distance learning, what you'll see is within that time period, the schools and instructors are required to have certain activities. And so that's really the time limit. Somewhere between 12 and a half minutes and 50 minutes creates a module, and there's certain requirements for schools as to what they need to do inside of every module of distance learning.
Licensing statuses. I don't know if you all noticed, but inactive in 2024 was redefined. So now we have rules around them, and we've included eligible. Again, eligible status, I know it's just a reminder for you guys, means your CE hours are up to date. You're just not actively with a broker, but you are eligible to hire with a broker. Where inactive, you can now be inactive for up to 15 years, keeping your license renewed, but not needing to take that continuing education course. But now if you read the rule, you'll see how many hours you will need to complete to go back into the industry dependent on how long you've been inactive.
Yep, that's it. The last one that we changed in definitions was residency. Hopefully this will help our licensing team, and this will help people that are trying to get out-of-state licensure and understand what our residency requirements are. So we defined it. You have to have a place of habitation, owner-operated business here. It's in there. It's probably not applicable to this current audience, so we won't go too far into that.
I don't know about you, but timeframes have always been important to me in my real estate business.
Yeah, so how you count timeframes. Does it start on the day of the action? Does it start on the day after of the action? Does it end on the last day? Does it end after the last day? We went ahead and we defined timeframes because the Department of Real Estate, just like you as a licensee inside of a contract, we have timeframes that we have to stick to in our administrative reviews and in our substantive reviews of applications. We have all sorts of due process timelines and everything. We wanted to make sure that our licensees understood how to calculate, how to count those timelines.
So just like you live every day, today would be day 0 and tomorrow would be day 1. So just keep that in mind when you're working with the Department of Real Estate, is we have the same time frames you are currently working with as well. One's pretty big, this next one.
Licensing disclosures, original license and renewal questionnaire disclosures, referencing and 10-year work history, support for the application. We tried to give you guys a little more detail again so that you could come to the Department of Real Estate with a complete disclosure in your application as to what we are looking for. So we went ahead and took a lot of things that were already a substantive policy statement or already something that was in effect at the Department of Real Estate in practice and internal policy, and we actually turned that into public-facing rules.
And just keep in mind, anytime there is a criminal disclosure to give to the Department of Real Estate, you should really reference that area of law, because this is what we're going to be asking for.
Yeah, and we used to only allow certified copies of things. That really was something a lot of licensees had a hard time getting. Some of their business disclosure things that they have are many, many years ago, maybe even decades ago, at a small courthouse in another place in the country. And getting certified records was something that was very, very difficult for them. So we changed the rule to say that we're allowed to accept copies.
Fingerprint clearance cards, quite a debate.
Yeah, quite a debate. So we're going to walk you through, because there really is no debate here and there really is no question here, but we know that licensees are receiving information from multiple different sources. Quite honestly, I guess we're the source that matters, because we're the ones that maintain your license. So it's the fingerprint clearance cards. Why is it important? If we go to the next slide, we can talk about the duties and the powers of the commissioner. And basically, under Arizona Revised Statute 322108C12, it says that I can require any information for the holder of a license. And specifically, it says a valid fingerprint clearance card issued pursuant to Section 411753.03. So let's talk about that particular section of statutory law, which I think is next slide. It was taken out of the deck. Okay, never mind. Go back. So the 2024 legislative session, a bill passed and it changed Article 41-1758.03. And what happened in there is it said that licensing agencies could receive notices from the Department of Public Safety, and it added that the Department of Public Safety would participate in wrap-back services. And the bill also defined what wrap-back services are, but basically wrap-back is criminal activity reporting from across the nation. So you're now participating in, if you go to Nevada or you go to Michigan or you go somewhere else and you commit a crime and you're arrested there for that crime, that's going to report back to the Arizona Department of Public Safety. And then the bill allowed that if the Department of Public Safety received a crime notification, a criminal activity notification on a holder of a fingerprint clearance card, and that fingerprint clearance card was issued so that the person could obtain an occupational license from a licensing agency, that licensing agency would receive notification. So that's really kind of the big change that happened in 2024. It became effective in September of 2024. And when we went to institute, okay, who has the card that does what the law that was just changed does, it was an astronomical number, and we didn't have a way in our computer system to allow licensees to know if you had the right card or not, to be able to upload the front and back of your card, to be able to submit it to the Department of Real Estate. So we had to enter into a coding project. That coding project was finished last summer. We did a rollout. There was some confusion. We had a stakeholder group come forward and say, hey, we're confused. We put a hold on it, and we went ahead and we completed our rulemaking to double down that what a licensee needs to have is the card that is called for in, it's 32-2108.01, which references the card in 41-1758. So really what's going on with the fingerprint clearance cards. And, the law reads before receiving and holding a license pursuant to this chapter that a license applicant has to have a valid fingerprint clearance card. So if your card is expired, you got to go get one that's not expired. It says that the commissioner may require it. And so this is your notice that I am requiring it. You do have to have a valid fingerprint clearance card to hold an Arizona real estate license. The effective date of when that is now. Go get it. The date that we will actually start to issue disciplinary actions and take actions against your license if you don't have it is pending, because the volume of licensees out there is too great right now for the staffing and our ability to process. So we're very closely watching as it comes in, but we are also going through IT modernization. So as soon as our technology has the ability to process everything in bulk using API technology, then that requirement becomes real. Licensees can expect to receive a 90-day, 60-day, 30-day notice that they need to get into compliance as a holder of a real estate license to have a valid fingerprint clearance card. So we are working as quickly as we can to get that information in and correct and be in statutory compliance.
And a big reminder for you guys, because this is kind of confusing when you go on DPS's site of, oh my gosh, there's so many cards. We're not speaking about a concealed weapons permit. I have that question come to me about 5 times a day. Please don't tell me. That is not the card that reports to us. The card specifically is a IVP level 1 card. If any of you have been involved in school districts, you have an IVP card. However, I need you to go back and get a non-IVP level 1 card. And when you're registering for that card, it will ask you if you hold an occupational license and with what agency. And you'll be able to select real estate. When the API comes into play with our new IT system, please note we will be verifying that information. So make sure when you're out there speaking to other licensees and yourself that you are checking the box real estate.
Yeah. So we can kind of breeze through the rest of these fingerprint clearance cards. In a nutshell, what you need to know as a licensee is if you are a holder of a Arizona real estate license, that I require you to have a valid fingerprint clearance card on file. Kind of one of my worst nightmares is that people procrastinate this and they wait until they receive that 90-day, 60-day, 30-day notice, because the actuality is we could be processing 50,000 at that time. And while we will have the automation that we know we need intact, Department of Public Safety is also involved in this and issuing the actual card. And so you've got some time, and I just encourage you not to put this onto your list of things that you procrastinate. Go out, get your fingerprint clearance card. And, it is my understanding of the statute. I had to renew my license, even though it's on ice. It still has time periods. I still have to do things in the background. And I went and got my fingerprint clearance card because I understand that that's what I have to do to be in compliance with the law. So if I have to do it, so do you. DBAs.
DBAs, how exciting. This is an area that people are a little interesting on right now, but the first thing I want to let you know, and we're talking about doing business as names, we do not only serve in the residential sector, which is quite different than timeshares or development services. So I understand that Marriott is a timeshare provider, and they have bought a lot of other companies.
Yeah, so has Pulte. Pulte Homes, they have other companies. And so these corporations are set up with a big parent organization, and then underneath them, they have different brand identities, but they have full ownership of all of those brand identities. And the law was written in a way where they would have to, manipulate and try and change their corporate structure or have undue, unnecessary, burdensome, extra. You have to hire an extra person. Why? Well, because that's the only way you're going to be in compliance with Arizona law. And so those are, really bad reasons. That's government burdening business for no reason that doesn't result in us better protecting the public, right? And so we worked with those stakeholder groups that came to us and said, we could really use some help here because you're costing us money and, there's really no end result. So you have multiple doing business as names on an entity license, provided the entity has the ownership.
And in the new system, it will actually be searchable for the public. So right now, how the law reads and how our computer system is set up, that you can only have one doing business as name. But in the future system, you'll be able to have multiple, so all will be searchable by the consumer. And that's really what it comes down to. Is the public reaching the person, the designated broker they need to reach if they have an issue?
Yeah, that's it. Showing services and qualifying agents. Oh, this is where I always say, if you walk like a duck and you quack like a duck, you're a duck. That's the way that agency works. Their implied agency is a real thing. One of the rule changes out there is that you can't go out there and perform licensed services just for a fee. That is not allowed. You're not a qualifying agent. Your real estate license doesn't allow you to be a qualifying agent. So if you're doing those activities, or if you're going into different Facebook groups and Facebook forums and things and saying, hey, I'm out of town, can somebody else do this and I'll pay you, you're violating multiple laws. You're not, your compensation has to flow through your brokerage. You can't do that. You're probably breaking your own broker policy manual by asking somebody from another brokerage to go and do licensed activity on your behalf. But if violating this rule, it's just going to stack and add on it.
And we see it every day. Mm-hmm. So let's really have agents go back to their brokers in all sectors that we regulate. Does the broker allow you to find additional representation from an outside brokerage to open a door? The answer is usually no, because that creates agency relationships with two brokerages. And usually the person standing up saying, hey, for this much money, I'll open the door for you, their broker's not even aware, let alone the customer or the client that is being served. So you can no longer do that. Does that mean within your brokerage, you can't have showing agents and listing agents and structures of that way? No, that doesn't take that away, because everybody within the brokerage has agency obligations to the clients of that brokerage.
Yeah.
So please stop going on Facebook, because I have investigators that have really heavy cases, and we're stopping and we're having to call you to say, it's not only that you're creating implied agency and not doing this properly, it's also that you're allowing the compensation to go directly from you to another licensee. I need you to take the post down. What you're asking for someone to do is unlawful. We're stopping everything we're doing to stop that crime from happening. And we have a lot of heavy, heavy cases here. And I hope you can help us by just stopping this situation and understanding that is now illegal.
Yeah. Yeah. You can't enter into an agreement with another brokerage to say, hey, you're not providing real estate services. You're just going to utilize your ability to go and do something that you can only do because you have a real estate license, and you're just going to do that, and you've got no other responsibilities, and we're going to exchange compensation. It's just not allowed anymore.
And I don't know about you, but I know about me. And when people tell me all they did was open a lockbox, they didn't even speak to the person. I don't think agents do that.
I think the public deserves better.
Absolutely.
Non-resident employing brokers. So we need your records to be immediately available, and you can do that by using online clouds and that sort of a thing. If you're establishing a branch office, you have to give a statement to the department describing how that person's being supervised because you're out of state. So if you have this branch office here, but you're out of state, who's supervising your licensees at your local branch office, incorporated statutory agents into everything, because if you have a home-based business and you don't want to use your home address as your forward-facing business address, you can now use a statutory agent. Licensee safety is something that's really important to us as well.
License renewal. Okay, designated brokers, get excited. We redid our forms in Form Frenzy from the governor's office. And one of the things we removed was you having to sign anytime your agents need to manually renew. Now, if somebody's under a consent order, that's a different set of rules. But some people don't love the online system to renew their license, and it required them to go in and get your signature to be able to renew their license. So we've actually removed that from the paper format.
Yep. We also added in there some sufficient details need to be included. Address of record, email address has been added throughout. Address of record, again, will allow for that statutory agent instead of usually it's somebody with a home-based business and a home address that wants to utilize that. And in general, we just kind of cleaned up this little portion of law to modernize it and make it match with the statutory laws that are there.
And just as a quick reminder, if you change your email address, remember, within 10 days, you also need to update your licensing profile. So when we are contacting you through the message center, you're receiving those messages. That hasn't changed. That has been part of law.
Yep.
I love this one.
Delegated authority equals mutual responsibility. Yeah.
Do you have delegated authorities from the designated broker? Because if you do, the advice you give licensees under that designated broker, you are now responsible for that advice. It was always easy to say, well, I'm giving you this advice, I'm the managing broker, but it's rolling uphill. So if we get in trouble, it's not me.
Yeah.
Well, that's not really right, is it? Because you're still involved in the communications. You're still involved in directing that agent and how they're representing that client or dealing fairly with that customer. So now if you have delegated authorities and you advise someone with that delegated authorities or take licensed actions based on those delegated authorities, it's not only the designated broker, it's also you. But keep in mind, right, Susan, the designated broker is still ultimately responsible.
Ultimately and always holds that responsibility in Arizona law. But if you're giving advice, what we really want to see happening here is brokers with delegated authority who maybe have a little less experience and knowledge base than the designated broker. If you don't know, consult before you give advice. Don't go out there and give bad advice and then have your agents posturing and breaking our laws. We are going to hold all levels of that accountable in the disciplinary actions.
We already kind of spoke about this, but inactive licenses, if you go inactive, no, they can't just come back tomorrow. Within the 2 years, they have to take a certain amount. And what I love is on that screen, you can see 10 years, but less than 15 years, you're going to need to take 54 hours if you have a salesperson license and 60 hours if you have a broker's license. And keep in mind, you can't take the same class twice.
And those are in addition to the 24 or the 30 that you would have already had to take. So it's a pretty high stack, but you don't have to take the real estate exam again. It's just a way to get you current on what's going on. Education. You must pass the licensing exam with 75%. I wanted it to be like 95%. And they were like, that's not reasonable. I was like, fine.
They always take us down a notch, right?
Right.
We're like, we're here, and they're like, here, but at least we're not here.
Yeah. So, 75%. 75% is the passing. There's no limit to how many hours can be taken in any one calendar day. So it used to be that you couldn't take more than 9 hours of continuing education in any one day. One of the things that we had to do when we went through this rule review was tie it back to our statutory authority to actually have these administrative codes. And I really couldn't find anything that gave me the basis. And when I thought about myself and my own knowledge base, I'm not I don't even know what kind of specialist it would be to say, like, what's a human being's capacity of how long they can, have good thought processes and retain information and learn. We have a lot of licensees who have full-time jobs, and they come home after working an 8 or 9 hour day at their office, and then they put in 3 or 4 or 6 hours to move toward this new career, toward real estate where they want to be. And we have other people that maybe have other jobs and they take 2 weeks off, and they're going to cram it in that 2-week vacation period, and they want to be able to take 10 or 12 hours a day, or maybe they could only take 3 days off or 4 days off, and they just want to drink it from the fire hose and go. And that law was restrictive to them. And I don't really have the basis to say, okay, yeah, you who went to work all day but only did 6 hours of real estate afterwards, that's okay. But you who took the time off and wanted to do 12 hours in one day, that's not okay. So, and there was no sort of statutory backing for it, so we took it out.
But I would like to make one thing very clear. You cannot take 2 classes simultaneously. So if you calculate 24 hours, you divide it by 3, you cannot take more than 8 hours in a said day, right? 8 courses in a said day, because that equals 24 hours. So just keep that in mind. If we find that someone's been taking classes, 2 classes at one time, no, you have 24 actual hours that you need to complete, not 12 hours that I did 24 CE credit units.
And did you know, when we audit distance learning schools, we actually look at simultaneous logins. And when we audit licensees' education records, which is all done on a random basis, but when those audits happen, we will, if you did distance learning, we will pull those records from the distance learning schools. So even going to 2 different distance learning schools to do a course in the same 3-hour period, and now you're going to get 6 hours and actually only 3 hours that moved on the clock, we're not going to allow that. You have to take one course at a time.
Now, I know all of the licensees on this call renew early. I know nobody waits to the last minute, so we're golden there. But now if you renew early, within 90 days prior to your license coming back up for your next renewal period, you can use credit hours that you haven't used previously for that next credit period. So go out there, renew early, take more classes, keep learning.
Yeah. What was hilarious to me is the licensees that brought this up as one of the things that really, really bothered them because they renewed early and then they took this great course and they had another 3 or 4 or 6 credit hours and that couldn't count toward their next license renewal. And when we looked at all of those licensees' histories, that was kind of a giggle, right? Because it's sort of, oh, well, you're required to have 30 hours. And last year you did 90, but okay, you can have those 3 that you did in that 90-day window after your renewal as well.
If it makes you happy, we could do little things.
Yeah, I'm not against more education. If that encourages you to attend a class and learn and sharpen your skills because you get to count that towards your next license renewal, go to that class. Go get that education.
A few changes before we move on from this topic. Commissioner Rules is no longer known as Commissioner Rules. It is, in law, Arizona Administrative Code, which is also is known as rules. However, we have named the course category requirements for licensees because there's a lot more than Arizona Administrative Code in those CE courses that you could be taking. Fair housing we updated to make our commercial folks happy, and now that's going to include ADA. Please go out there and write more courses if you're an educator and get some more things going on these topics. And then business brokerages may be allotted to satisfy legal issues, contract law disclosures in general. And what I thought was funny, Commissioner, is I literally in 20 some years have never met a business broker licensee. And then I met a whole association of them because we were just going to strike it like, I don't know, I've never met one. And they came back and they said they're going to write courses. So hopefully this year we'll see some more business broker courses out there.
I know. And we exercised great restraint because we didn't go like, oh, you're real. You exist. Where have you been? Write some courses.
I made sure they bought a law book, though. By the way, our law books will be in sometime in 2026. You can always come down and purchase yourself an actual tangible law book.
We do like our paper.
I do like it.
Yeah. Oh, distance learning. You have to have some scenario-based questions. So, we were licensees. We know how the distance learning works for a lot of people. You have 2 screens open, you're working on a contract here, and then this other screen, you're like, oh, hey, look, the timer's up. I can move that slide. And then you get to like the silly little 5 questions because you didn't actually read any of the content that was before there. I'm not saying this is all licensees. I'm just saying it has happened. And
nobody on this call, Commissioner.
Right,
don't worry about it.
Right. And as long as you picked up what was underlined and in bold in the slides that you were skipping through, then you already had the answers to those 5 questions because that was like a real thing too. No, you know what? We're going to do some scenario-based questions because what we really need is licensees to be able to apply in real estate situations what they were supposed to have learned. I don't need you to just regurgitate a definition or give me a cheap, true or false kind of answer. I need you to understand what your behavior needs to be in certain situations based off of what you should have just learned, and I need you to act properly. So you're going to see scenario-based questions. That's a new requirement in law.
And if you're taking distance learning classes, which many people do, we are requiring that schools authenticate that the user is the licensee. I don't know if you've received the text messages, but it's like they forget that we left that world and they keep texting us too. Hey, are you too busy to take your CE for $50? I'll do it for you. Was one of the texts.
Yes, tell me more. Send. How does this work? Question mark.
And we have found that people have hired people or have their assistants taking their continuing education, and this is not okay. So will there be additional requirements for you to be able to take distance learning? Absolutely. Each school has the right to make that look differently, but they need to find a way to certify that you are the one taking your education.
Yep. Advertising by licensee. We are getting a lot of questions on advertising.
Well, I'm wearing a shirt today and it says Mandy, and I'm a licensee. Does that need to have my brokerage?
It says Mandy. Does it say that Mandy is a real estate licensee?
No, it just says Mandy.
It just says Mandy? No, you can wear a Mandy shirt. That's okay still.
But I would need my brokerage if it was anything to do with my license capacity, like my phone number or my team name.
Yes. If it said Mandy, licensed real estate agent, then it better say where Mandy works, who her employing broker is, because now you're advertising that you do real estate. It's like your name tag, right? If you have a name tag that says you're licensed to do real estate, and that name tag is a mechanism of marketing, we are hoping someone comes up to us at the grocery store and says, I need to buy a house, right? Like that's why you wear it in the grocery store. And
I wore it everywhere.
Yeah,
I miss that. I miss my sparkly name tag. It was like the happiest place. And my pens. And you know, my pens and my sparkly name tag always had my brokerage listed.
That's right. And so we get these questions like, if it's something like a pen and it's really, really tiny, does that have to have the broker's information on there? Does it have room to have the licensee's name and that they're licensee? Yes, it needs to have the brokerage name. Well, what if there's not room? Well, then they have to pick the brokerage name and not their name. Maybe they want a different medium to advertise their business. You know,
find a pen. There's plenty of pens.
And you can get both on a pen, because I had pens and she had pens, and it had our brokerage and it had our licensee information
and our phone number.
Yeah, you can get quite a bit on a pen. You'd be surprised.
So it really comes down to all real estate advertising that you do must have your brokerage listed. You're not being unique and different by not listing your brokerage on your advertising. Actually, your brokerage is the one that stands with you. If you have an issue, they're the ones that back your client when you're not available. So be proud of who you're with and make sure that the public knows who you're with.
Yeah. And then, the broker is responsible for all advertising of real estate activity. The law used to only require the broker to have responsibility if it was to a specific property. And now the law requires that if you're advertising that you provide listing services, or you're advertising that you provide property management services, and you're not particularly promoting a particular property, the broker is still responsible for that. The advertising law that your brokerage needs to be prominently displayed is still there. How do we look at prominently displayed in audits, investigations?
I should be able to glance and know it should be equal size.
At least.
Or bigger.
Yeah.
So it shouldn't be hidden. And keep in mind, when that update to 502 came around for brokers, it did not actually change the law in 1103. So in 502 in that code, what it was about listings like the commissioner said. But in R4 281103 A5A or B, but it's right there somewhere, so you guys are going to have to go reference it. It always held the broker responsible for all advertising. So this isn't new, this is clarity. This is aligning the two codes. So if you're out there like, well, how am I expected to do that? Well, you were supposed to do it before December 13th. So how were you doing it then? And per 1103B, please make sure you have a system in place to at least be proactive to try to the best of your ability to give reasonable supervision and control to those situations.
What else do we have? Here we go. More advertising.
I can't believe people actually place signs in people's yards
without permission.
This job has been mind-blowing.
So we had to make it clear.
Yeah. You need written permission from the owner of the property. And you might want to ask some more questions if you're unsure they're the owner before just going and placing a sign.
Yeah. Not a good idea. It really upsets people. They contact the Department of Real Estate and they're mad. Don't do that. Compensation sharing disclosure, at least 3 calendar days before close of escrow. If somebody has performed representation and they're getting compensation, consumers should know that. So does that mean, Mandy, if I receive a referral and you're an agent in Florida and I'm here in Arizona and I get a referral from you and you say, hey, Susan, met you at that conference, you're great, here's a client for you, and we sign into an agreement, does that have to be disclosed?
No, because
No.
that is not representation. But if I was from Flagstaff and I referred you a client here in Peoria and then I overstepped my bounds and started creating implied agency, I'm receiving compensation. It might be a referral, but it's based on my representation. That would need to be disclosed.
Yeah.
And again, it's not the licensee themselves, it's the brokerage.
Yeah.
I know this is a hard breakdown, and I hope most of the industry has really realized this. But the designated broker, the entity, is who receives the compensation. Your independent contractor agreements or other agreements that you have with that person is what allows the licensee to be paid. So we want the employing broker.
Yeah. And okay, let's talk about opening doors, right? Because we just had that conversation about how you're not allowed to just open a door for a fee and say, like, there's no representation here. I'm just opening a door for a fee. I'm just, like a qualifying agent. We aren't allowing that anymore because there's a new law. So I receive compensation. I open a door. And I mean, clearly I must have been representing that person while I was there because I'm not allowed to just do it for a fee. I'm not allowed to outsource licensed activity to receive fees. So I would have to disclose them, wouldn't I?
You would have to disclose to all parties.
Yeah.
Now, a big misunderstanding is, how is this disclosed? Is this rule completely new? I will admit, it took me about 5 years in the industry before I even knew about this rule, and I was just lucky it was happening. 701 has typically been done in traditional real estate transactions with the settlement statement. The settlement statement would list who the brokers were that were receiving compensation for representation. That's at close of escrow, though. Most of the time, a settlement statement is created. It might not be the final, prior to close of escrow, and it could still list those items and be disclosed to the parties, and that would suffice. But I want you to be really, really clear that representation and compensation are not always the same thing. Actually, they're not the same thing, but in that vein, you can't say, well, it was on the contract. My brokerage was on the contract, because that's about representation. Compensation comes down to who is receiving compensation based on that representation, and that you really don't know all the brokerages involved sometimes until close of escrow. Mm-hmm. And we need that disclosed 3 days prior.
Yeah. So if you're performing licensed real estate services and you're receiving compensation 3 days prior to close of escrow, that should be disclosed somewhere, somehow. Thank you.
Ooh, I love this one. Expeditiously. I used to have to practice how to say this word just to teach this word. It was kind of like when I watched Mary Poppins and we'd say supercalifragilisticexpialidocious, and I'm like, oh, I'm going to get this down. Expeditiously, it turns out, has an actual meaning, guys. It means as soon as possible. It doesn't mean while you're driving down the road, but you parked in the parking lot, you have that counter, and you have the ability to get that over to your client, you better do it. It's that sense of urgency. In section 802, so this is R428-802, conveyance of documents. Yes, I have a problem. I hang out with my law book way too much. In that section in A, it said as soon as practical. I'm sorry. I don't know if you've met people who are like, well, I have the flu today, so today is not practical, but I've never had the flu extend a contract. I'm just going to put that out there. So now we've moved that to...
I think you're being generous with the flu. I had a Pilates class, and I had to go grocery shopping, and it just wasn't practical.
This is so interesting to me. So now it's aligning.
Yeah.
See, in 1101, R428-1101, which we'll get to in a moment, it always said expeditiously performing any act resulting from a real estate license. Now, 802, I'm pretty sure conveyance of documents to your clients and customers is still a licensed activity. We're just aligning them so there's no confusion of what the threshold is for obtaining documents for the client. Because I don't know if you realize, but once you receive it on their behalf, it's received.
Yeah. And, so expeditiously brings consistency to our title and chapter. It's in one place. It wasn't in another place. It's expeditiously all over the place now.
Oh, I love this one too. This is an 802 as well, our 428-802. I believe it is section C. And this ties back to the statute ARS 32-2151.01 on transactional files that the broker is required to maintain. And there seemed to be some confusion in the industry in regards to what a disclosure is versus a consent, what you have to keep. Commissioner, would you go into that?
Well, a disclosure is you telling somebody else something that they need to know. Doesn't require the other person to sign it. So, proof of delivery is what you actually need to have at a minimum inside your broker file and inside your personal records, because licensees also have to maintain records for 5 years. And so anyway, you want that proof of delivery. So stop telling people to sign your brokerage's forms that are, notices and disclosures. It's not required. What is required, though, is that, I would encourage you to blind copy yourself on those email transactions or utilize an online forms system. If you're already utilizing one, send your forms that way, because there are receipts and that's very easy for you to prove to the Department of Real Estate. Yes, I sent it. I sent it here, and it's going to have the time and the date stamp and the certificate and everything else. But also what would work is a BCC to you that shows that went and it went out and the email addresses were correct and it was delivered.
And you need a way to definitely show us what was attached. You can't just, oh yeah, I attached it, but with no evidence. So just keep in mind, documentation is proof. So you always need to show. But now the brokers are going to be responsible to verify that information has been disclosed.
Licensee's duties. A licensee shall disclose in writing to all parties any known adverse material fact concerning the property or material defect existing in the property being transferred. Is this new, Mandy?
No, I'm pretty sure if a licensee knew it, they always had to disclose it.
Yeah, and then there's that word that we like again, expeditiously. A licensee shall expeditiously perform all the acts required that are required because you hold a real estate license.
But then we added to it.
Not delay. Yeah.
Yeah, and we added to it because now we want you to expeditiously inform your broker if you're not going to be able to meet those requirements so they can take over.
Yeah.
And I'm sorry, but I'm pretty sure if you're going to a Pilates class, you could expeditiously let your broker know that you're going to a Pilates class in lieu of conveying documents and that you need their assistance.
Yeah, and if your broker keeps you, that's a very generous, nice broker that you have there. I wouldn't have. I would have.
I am so excited about this slide, Commissioner.
Licensee's duties.
Scope of expertise.
Oh!
I was so disappointed in this area most of my career and didn't really think much about it until I got here. And one of the items was that your area of expertise was limited to what you knew to pass that real estate exam. You tell me, what you did to pass that real estate exam, did that really assist you so much in your business that you understand how to represent a seller with solar on their roof?
Or easements.
Oh, easements are a huge deal. Or reading a prelim?
Yeah.
Oh, the things we could go into. So now it's going to be expertise in that subject area.
Yeah.
Keep in mind, if you don't have the expertise, you have to disclose that to the client, who's not the client yet. It's a prospective client. Have them employ you in writing with that disclosure, and then you can move forward. And, well, actually it says or. I wish it was and. Pair up with somebody that does have the experience. And brokers have the right to have policies on top of this rule. But at the end of the day, there's lots of mistakes that happen when it's, oh, you know what? I'll fake it till I make it. Don't fake it.
Don't fake it. Don't fake it, because what you end up doing is you make your way here for an investigation.
Yeah, I'm busy.
Licensee's duties and access to the property. Like, it is so sad to me that we had to make this a law.
I didn't get that people didn't get not to give keys away.
I don't know, but we had
It's like, oh, look, you're going to be a homeowner in an hour. Don't tell them I gave you the key.
We actually had a licensee that walked into somebody's house without permission.
And did a commercial. Shot a whole commercial. Like, I'm setting up a showing for a prospective buyer, but I'm going to shoot a commercial. Hey, check this house out. It's not the listing. It's nothing. That is access to a property without permission. Was the owner upset when they saw the video?
They were really mad.
Yeah. And we had another licensee who thought the way to get a listing was to walk right in the front door and announce themselves and force that person to talk to them so they could talk to them and sell their house.
And when the homeowner said, "Who are you and why are you in my living room?" and was terrified, The licensee said, well, I'm a real estate licensee, so that gives me the power to walk through your front door and ask you if you want to sell this house. No.
See, that person had a buyer.
Yeah. Anyway, you have to have permission. Please get permission.
Oh my gosh, Commissioner, I just really wanted you not to change this one. This one breaks my heart.
You loved this. You loved this
one
when
was
you were
my
in practice.
favorite code.
Yeah.
So R4281102 was so misunderstood because it's from I think this one was actually from the 80s, if I'm truthful, early 90s, late 80s. And it was all about you had to wait 24 hours if you were a buyer's agent for the brokerage and the listing agent to respond to you before you could go to a seller, obtain their permission, and present the offer directly to them. And people misunderstood this because they say, well, the listing agent. No, the listing brokerage. So that meant every licensee within that brokerage you had to contact. And I really enjoyed this because it meant they would never get to my sellers.
So, given the size of brokerages today that have thousands of agents, I was like, well, that law is stupid. We're striking it. And we did. We replaced it with the next slide that basically says you have to contact the listing agent, the managing brokers if they have delegated authority, the designated broker after you've made those attempts in 24 hours, regardless of what side of the transaction you are on. Go present. Go do what you need to do.
Obtain written permission from the other side and then present.
Yes.
Don't just do it for fun. Okay.
Broker supervision and control.
That's something, I would always go to these trainings and I loved all my trainings, but when I heard people speak, they'd always stop at reasonable supervision. And then the redhead in me came out when I took this job and I was like, hey, Commissioner Nicolson, it says, and control. And it talks about systems and being proactive and not saying things like, how would I know? So we're helping you because the rule sets already allow for us to uphold the fact that the broker has to give that reasonable supervision and control, but tell them about that progressive disciplinary.
So, here's the thing. Brokers were like, but what does it mean and control and how do I do that? Well, you do that through a progressive disciplinary policy. So your first offense might look like a verbal warning. Businesses can set this up for themselves. They know how to reach their agents and get the behavior that they need. Verbal, written. But what's not okay is just like warning. That's not changing the behavior. It has to progress up. It has to become more severe. Each business can determine what that's going to look like. But these are only for violations of policies and procedures that are also violations in law. And please trust me when I say this. You want to solve these problems at the brokerage level and not at the department level.
I just think about all the harm someone does not even realize they could be making in a transaction because they did not turn their paperwork in timely to understand what they wrote in that contract was unlawful and not even and completely ambiguous. For instance, as is, just writing this property will be as is. Well, that doesn't give what you need to know to deal fairly with the other side, let alone your client understanding, right? And so we were sitting there and you think a broker's going to just know what's put in those offers. They don't know until they receive it to review it. Then the broker could step in and say, okay, we need to define this. This is not enough. This does not state enough. What did you mean by this? And then make sure what is meant by it is actually lawful, because telling a seller they can waive their obligation to disclose material facts is not lawful.
Yeah. Okay, I think we covered it.
Oh, you have the right to representation. I guess Liz wants us to talk about that.
Liz wants us to talk about that. If you want somebody to represent you when the department is taking an enforcement action against your license, you need to tell us that that person is representing you. So please don't have your lawyer contact us and say, I'm representing so-and-so. We need so-and-so to say, I've chosen so-and-so to represent me, to authorize us to go ahead and interact with them.
And you can request a notice of representation from the Department of Real Estate. We'll send it to you and you'll tell us the capacity in which to work with your attorney. We follow your instructions just like you follow lawful instructions from your clients.
I feel like our audience faces are like, well, duh. And, if it weren't an issue, we wouldn't have made a rule. Okay. Thank you. That is it. Really, that's all we have. The Department of Real Estate is here to help you be successful. We really want to be your partner in success and not see you come to us for disciplinary actions. We do our very best in answering questions as they come in. We cannot give you legal advice. Please don't ask us to give you legal advice, but we will help you in any ways that we are statutorily permitted to do so.
And you can find us on YouTube, Facebook, LinkedIn, X, and we have a podcast on iHeart, C-Suite, and Spotify, which you'll find at the bottom of all of our newsletters and also on our website.
And you can sign up to receive our newsletter, which we push out on a quarterly basis as well.
And we didn't cover everything. So again, go back and read it for yourselves. Reach out to us. We work with brokerages one-on-one on a regular basis. We try to help licensees as well, but we do have to push you a lot back to your broker because we could talk about the law, but your broker policy is on top of the law.
Thanks
Thank
for
you.
joining us.